during the presentation, raise your hand. It's a conversation. This isn't, I don't mean it to be overly academic, so just if something comes to mind, let us know and we'll try and answer it. This presentation is about debt collection, but it's a little bit broader than that. What I mean is, we're going to go into with some slides. I think it's reflected in the outline that you have there. How do you avoid, if at all possible, and speaking to everyone as business people as opposed to individuals, how do you avoid having to worry about debt collection to begin with? Once you've determined that you do have a debt that you need to collect, how do you make a reasonable business decision whether to pursue it, and if so, how to pursue it, in what court? Perhaps you do it out of court. We'll go through some of the specifics of how you pursue things legally. Let's say you are successful in getting yourself a judgment. How do you turn that judgment against a vendor or a client or some other type of customer? How do you actually turn that into money? Because who cares if you're successful in court if you can't turn that into actual money? It's all sort of just an exercise. And at the end, Josh Wellborn, one of our associates here at the firm, is going to cover some bankruptcy issues. And I may touch on that a little bit as well. Because when you have a client or a vendor or supplier who goes into bankruptcy, all the rules change and change very, very quickly. And you have to really watch your P's and Q's. Get in a lot of trouble if you go after a bankrupt judgment debtor. By way of background, I am a civil litigator as well as a bankruptcy attorney here at the firm. I don't do any personal injury work, I don't do any criminal work, or family law, or anything like that. I tend to do mostly business litigation in the circuit court, sometimes in the federal courts, and I also do bankruptcy work on behalf of debtors who are filing bankruptcy as well as creditor clients of mine. I have some banking clients who have borrowers who file for bankruptcy and do that type of thing. I went to college in Baltimore. I went to law school in Philadelphia, at Villanova, and I worked in Delaware for 5 years in corporate bankruptcy. I worked on the Fruit of the Loom Chapter 11 case and Heckinger and all these very nerdy, exciting cases. So, on that note, let's begin. And forgive me if I don't get through our. Let's see if I can figure out how to use it even. Any suggestions, Laura? But you know what, while Laura's doing that, why don't we take a minute, if not embarrass everybody too much. It's nice to know who's here. So maybe we can go around the room and just give your name and where you're from.
You waited till my mouth was full.
That was on purpose. That was on purpose.
You watched me, I saw you.
Who can I embarrass?
I'm Flo Bailey. I'm with Long and Foster Real Estate.
Okay.
And
Cindy Michael.
And where are you from?
Cindy Michael with Calvert County Public Schools.
Sheree Marco with Calvert County Public Schools. I'm Katie Cotto. I'm the intern here at Davis Thompson Employment.
I'm Tracy Moore with Exit by the Bay. I'm here in Prince Frederick.
I'm Jean Hearn with Exit One Stop Realty in Dunkirk.
I'm Denise Wiley, and I guess my interest in this is more private business ownership. So, for my husband, I'm coming in for him. So,
I'm John Botek with Chesapeake Collision.
Jeff Crowley, A&O Realty, Chesapeake Beach.
Jared Crowler, Community Bank of Tri-County.
John Buckmaster, Community Bank of Tri-County.
Regina Lawrence, Long and Foster.
Thank you, Regina. And thank you, everybody. I hear like bebops. You know what might help turn it on? There we go. A good place to start is that, you know, very often I'm the guy that people don't really want to talk to, because if you're talking to me, and I'm putting my litigation hat aside, in terms of thinking about debt, nobody ever wants to think about, if you're a banker, a loan that doesn't perform, or if you have, you know, if you're selling goods or services, you don't want to think about a customer who doesn't pay. But it does happen, and very often people don't want to sort of face the reality of it, but that's part of my job, is to talk about efficient ways to try and make your yourself, make you whole. Bad debt is bad business. The early slides here we have are talking about how to avoid having to get into this decision-making of, God, do I go after this guy? Do I not? How do I do it efficiently and in a cost-effective way? So, some of this is a little obvious. We're in business to make money. You want to, as you establish relationships with different clients, depending on what your business model is, fees and costs, you want to avoid those disputes, overdue accounts receivable, and losing the actual client. It sounds obvious, but a lot of people use shelf documents. We refer to them as shelf docs, contracts that maybe haven't been revisited in a long time. So it's good to get back in and really go through and very critically look at your contracts. If you do have standard forms that you use, what is it we're selling? What's the good or service that we're selling? What are the costs and what's the cost structure for the customer? What are their payment terms? And what variables are there? If you're in a business that can get a retainer, we recommend doing that. You're probably not, as a realistic practice, going to be able to get whatever your entire projected cost is up front, some sort of flat fee arrangement. But if you can hedge against a potential loss in an industry that allows for it, by all means get a retainer. Getting back to contracts, I encourage everybody who uses standard form contracts, when you leave here, go back and take a look at them. Be a real critical reviewer of them. This stuff sounds so obvious, but you'd be surprised how often it comes up that in a contract between individuals or even corporate entities, there's no clear identification as to who the contracting parties are. Joe's Plumbing. Is that Joe acting as a sole proprietor, or is it an LLC, or is it a corporation? You want to make sure you get the names correct in the contract, because if you don't put, the law will allow for some variations. If it's Joseph with an F as opposed to a PH, that's not going to stop you from being able to go after him to collect. But you name the individual in your contract, and you're actually doing work with the company, that's going to be a problem. Or if you name the company, it turns out the individual is who is approaching you to go into business, that's going to be a problem as well. Guarantors. If you are entering into a relationship with Joe's Plumbing, do you want to get Joe himself to sign on either as a simple delineation in the contract, a paragraph in the contract that he'll guarantee personally the work that his company does, or do you want to actually enter into a separate guarantee, a separate arrangement, a separate contractual agreement to guarantee if Joe's Plumbing fails? If Joe's a sole proprietor, or if you all have businesses where you are sole proprietors, there's no longer going to be a need for a guarantor, because if you call yourself Joe's Plumbing, but you are Joe, DBA, Joe's Plumbing, you're already guaranteeing your work. And if you've got a judgment against you later on, all sorts of nasty things can come into play, and we'll get to that. But be real clear, who is doing what, and who's dealing with whom. This is almost sort of a no-brainer for us, but it does come up. Use a written contract when you can. Contracts that are not in writing are enforceable in almost all states under certain circumstances, but you don't want to, down the road, have to build those circumstances up when you could have taken the step to put it all on paper. These are all sort of contract 101 things, but again, important to keep in mind. Exactly what's being performed, what's being contracted for, what are the expectations of the parties at the outset. When is it to be performed? Is there going to be a draw, like in a construction contract? Is it all going to be up front if you've negotiated a flat fee of some type? Is it going to be collectible at the end, which I would almost never argue for? What are the payment terms? What's the interest rate on late invoices that go beyond a certain date? Here's one of the ones that people tend to ask about a lot. They don't pay. What do you get? Well, depending on the facts of the relationship, you may be able to get the unpaid amounts, and we'll talk about all of that and how you go about it. But what flows from a default under the contract? Are you going to be able to get your costs if you have to file a lawsuit? Are you going to be able to get your attorney's fees, which are separate from court costs? And this is a good example of an attorney's fee provision that you see in a lot of contracts. Whoever, if it has to be turned over for collection, the client or the vendor is responsible for the cost of collection, including attorney's fees, equal to 25% of the amount due. There's also a provision there about a default interest rate. I typically see those default interest rates in the loan products that some of my bank clients do, but you can put them in a very simple commercial contract as well. 25% of the amount due. Time for a little story on that. That can be in the contract. Do not go investing that 25% before you get it, because I've been in court, particularly in district court, which tends to be a little quicker and it's where small claims are brought. And I've been successful, and I've gotten a judgment. And my judgment, my attorney's fee provision like this in my fee, based on the term, was let's say $2,500. And the judge said, "That's great, Mr. Daugherty. I'm going to give you $1,200. Take it and be glad for it to get out of here." What are you going to do? Well, you can complain, but it doesn't do you a lot of good. There are appellate rights you have, which I don't think I've ever taken an appeal based on getting less attorney's fees than I thought I was entitled to per the contract, and you have to talk to the client about the efficiency of pursuing that. But what I'm saying is, that being the case, that you may not always get them, the judge may not always award them to you based on the circumstances of the case, put them in your contract. Because if you don't have it in there, then you'll never get it. Go default interest rates. You notice we had all these nice lines in here. Okay, so you have not been paid by your client, and you sent a demand letter and said, how do you plan on paying the arrearages? And the contractor already accruing late charges, interest payments, that type of thing, and you're getting stonewalled. The time comes to decide whether you want to pursue this thing in court. That's before you can do anything else to get paid. You have to have an adjudication. You have to have a statement by a judge saying you're actually entitled to this thing, meaning whatever the circumstances of the case are, you did the work, you provided the service or the goods, you did not get paid, you're entitled to be paid. You have to make some strategic decisions about where you're going to bring a lawsuit if you decide it's worthwhile. And a third of the conversations I have with clients are probably about, do I do it or not? Do I actually bring the case or not? Because it's not something to take lightly. You don't do it, it's going to sound funny. When people come in and say, Paul, this guy owes me money, and it's not a lot of money. It's not the money, it's the principle. And I say, with all due respect, it's always the money. And it doesn't mean I'm not a principled person. We don't all try to conduct ourselves in a principled way in business and otherwise. But don't put blinders on. If it doesn't make economic sense, you're going to be upset, and then you'll be upset at me for convincing you had to file this lawsuit. So I try to have a very, very blunt conversation with clients early on about, does this make sense? Look at it holistically. Look at it as a cost of doing business. Is it really worth it? And it's a good point up top. You want to obtain a collectible judgment. If you can't turn this thing into actual dollars, there's really no point in doing it. And do you want to pay me, $7,500 to collect that $2,500 on principle? The goal in any litigation is to get a judgment, that adjudication I talked about, an actual order entered by the court saying that someone owes you money. It is not in and of itself an order to pay. And it sounds like a made-up story, but it's actually very real. At clients, we were in the circuit court, we had a $75,000 judgment, and literally walking out of the courthouse, they wanted to know which clerk's window they went to get their check. And it was a real sort of splash of cold water to tell them, getting the judgment's only half the job. You then have to turn it into cash if you can. So that's what this conversation is about. Is the judgment's great. Put it in your back pocket. I think this is in a later slide. It is good for 12 12 years, and as long as you renew it every 12 years, it's good forever.
12 years.
So, but in and of itself, it's nothing more than a piece of paper, and don't think it's a lottery ticket, because it's not. Below the not in order to pay, can act as a lien on any real property owned by the debtor. This is a nice backstop. If you get a judgment, in addition to the other things you can do to turn that judgment into cash, if you have a judgment entered in the circuit court, and we'll talk about the difference between circuit and district later, it has to do with dollar amount and types of remedies you want. But if you have a judgment entered in the circuit court, it automatically acts as a lien against real property owned by the defendant. That's a good thing, because you can do something with a lien. Most of all, you can use it as leverage, because in the end you probably don't want to use that lien to take the property. Maybe you do, depending on the circumstance. But in the end, liens on real property frighten people. I'm a nice guy, but I'm not above using fear to get my client paid. You have to get into looking at, if that's the case, what other liens might be on the property. You may be the fifth guy in line, and the lien's not worth anything at all. But anyway, circuit court, a judgment is a lien automatically. In district court, which is where small claims are brought, a judgment can be a lien, but you have to actually ask for it to become a lien. There's a process for that. There's a little sort of foreshadowing here for Josh's presentation on bankruptcy, but we talk about the judgment-proof debtor. Somebody comes in and doesn't have any assets, or, like we talked about before, naming the right party. Joe's Plumbing probably doesn't own anything. It's a separate corporate entity, an LLC or a corporation. Probably doesn't own anything at all other than its accounts receivable or goodwill or whatever else. So if you get a judgment, you get a $100,000 judgment against Joe's Plumbing in the circuit court, if there's no real property that it owns, because Joe himself probably owns the real estate, or a separate entity has been created to own the building where Joe's Plumbing works out of, you're not going to have a lien on anything at that point. Judgment-proof debtor. I represent people as defendants as well when they're being collected against, and companies when they're being collected against. And I don't call it a tactic, but it's a real position to take where, and I've had success with it, particularly in mediations, where you start your lawsuit, the judge says, I want you to go mediate this with a third party. And they're going to come out with a recommended resolution, and you can take it or leave it, but it's sometimes a nice way to resolve things efficiently. I have used the assetless status of my client, whether it's a corporation or an individual, in mediations to say, you guys can get whatever, we can agree to anything you want, but there is no asset out there for you to collect against. Therefore, you ought to take the very little bit of cash that we're putting in front of you or whatever else, because if there are no assets to collect against, you're going to have that judgment, and that'll be wonderful to stay in your desk drawer for the next 100 years, which is never going to turn it into any money against my client. So why don't you take the bird in the hand, which is what I'm offering you now. Yes?
I have a question on liens on real property. Does the property have to be in the same county or state?
It definitely has to be in the same state, and it also has to be in the same county, but you can transfer liens from county to county, and I think they're recognized immediately. If you want to transfer a judgment between states, you actually have to file it in that state in full faith and credit.
With their circuit court?
Or the equivalent, that's right.
Or
But there won't be any administrative or jurisdictional problem with that, because all the states honor one another's judgments. But you have to transfer it. It's not automatically honored nationally. That's part of what you're asking. Yes?
I have a question. I filed a lien against someone.
Okay.
And then they filed bankruptcy.
Yep.
But there was a time frame. But then I tried to go into the check.
Mm-hmm.
But now
You should be for your election.
I went the whole gamut.
Yep.
But now that was several years ago, 4 or 5 years ago. I still haven't gotten paid. I had to do 2 liens because when I did it in small claims court, they would only let me do up to a certain cash amount.
Right.
My question is, will I ever get, they did pay me some money finally, but will I ever get fully paid? I mean, you know, when suppose they don't ever sell their house.
Right, you would have a claim potentially against the estate, I believe, when they die and the estate's being liquidated, the value of the house is there.
So,
But if they, what, and
Well,
we'll get to the sort of the tools of turning the lien into money and the other enforcement actions, but, you know, there may be a house that's, you know, $500,000 in value. It's got a first for $300 on it. It's got a second for $100 on it. Somebody gets a judgment in a lawsuit for $100 on it, and then I do the landscaping for the guy, and he doesn't pay my bill for the summer, and it's $4,500. I can get a mechanics lien or small claims lien on there, but first in time, first in right, in terms of liens, and most of you probably know this. I can, for my little $4,500 mechanics lien, he didn't pay me for mowing the lawn, I can foreclose on the house, but the proceeds of the foreclosure have to pay off everybody else who is ahead of me. So, as complex as foreclosure is these days, and there's so many consumer protections, I'm not going to file a foreclosure action to pay off all the senior lenders or senior lien holders and to leave me with nothing. So what I may do is what you may be in a position to do is wait along with all the rest of us to see when the market comes back and the house gains more value, or they pay down some of these other debts. Wait until there is equity, wait until there is value in trying to use that lien to foreclose.
Okay, I guess my question is, will I have to do anything else? I mean, they filed bankruptcy. I did have my, I used the lien to get it when you have the plan, and you have things on the secure side and unsecure side. So I had mine put on secure side based on the lien. Will I have to do anything else?
No, and you should be getting payment through the bankruptcy plan on account of your secured lien. Are you not, or have you not?
Well, you know that long list line that you were talking about? They did come up with a dollar amount. But then I didn't get what they said. And so then I did go to the U.S. court. And so then they did decide that they were going to start paying me monthly. And then they did start paying me monthly. But then they stopped halfway through.
If you have, and we may want to talk about this after the luncheon, but if you have an allowed claim in a bankruptcy case, if you are secured, you're going to have to be made whole through the case. If you are unsecured, you're going to get what you're going to get, and the remainder will be discharged. And there are a number of factors that play into that. And what you're describing sounds like a case that for some reason...
I was secured.
Right. If you stopped receiving payments at some point, and it was before you were made whole,
Yes.
your lien may have been what we call crammed down in some fashion, or if payments suddenly stopped, there may have been a failure of the plan due to lack of funding or for some other reason. But you got me a little bit curious. Maybe we should talk after lunch, because there's some fairly specific things going on there and some specific reasons why you may not have gotten paid. And if the case got dismissed, you're back to having your lien. You'd only have to net out what you already received, and so you may still have other options available to pursue the remainder of that amount.
Well, I know it did get dismissed.
The case
did get dismissed. And then 2 years later, they filed again. Bankruptcy again.
Very, very limited circumstances in which you could do that. So
They
I'd be curious
filed-
to learn how it happened.
Yeah, they filed again. When I went back and looked at, I'm not going to get into all this, but when I went back and I went online, I saw that this wasn't the first time they had filed bankruptcy.
In 2005, the Bankruptcy Reform Act was approved and went into effect in 2006, and one of the big things they did there was put limitations on how soon you could file in succession. Mostly to stop what we call serial filers, people who filed every 18 months and just ran up a bunch of debt. And the limitations are pretty severe. I mean, you've got, usually it's several years between times that you can file.
I think they waited 4 years and then they filed again.
Yeah, yeah. It's narrowly permitted, but I'd be happy to talk to you about it. See if you got any, still have any dog in the fight. And if you don't, I'll tell you.
Okay.
always say, I consider myself to have two main duties to the client. One is to advocate for you, to fight for you. The other is to be blunt with you when no one else will. Because you don't, if you have a lawyer who tells you everything peachy and you're going to get every penny and everything else, everything's going to be great. Get up and walk out. You need bluntness in legal representation. All right, so where are we going to file? District court. This is essentially, we'll refer to it as small claims court. It's under $30,000. It's the only place you can file if you have a case for $5,000 or less. Despite what's up here, if you need a jury, you need to be in circuit court. Circuit court is over $30,000. There's a number of details about concurrent jurisdiction. There we go. The takeaway here, and it's in your outline, if you're under 30, you're going to be in district court. If you are over 30, you're going to be in circuit court. Well, that doesn't tell you a whole lot other than it sort of pigeonholes things for you. Why would you care? Well, in district court, you're generally going to file your case and get to some sort of hearing in about 45 days or so. The timelines for doing discovery, meaning interrogatories, requests for production of documents, depositions, and those types of things, very, very compressed in district court, to the point where we don't often do them because you can't get them done in a very meaningful way. Circuit court, on the other hand, anything over $30,000, you're not going to get to a trial for about 18 months in Calhoun County or in most of Southern Maryland. But it allows for longer periods of time for doing in-depth interrogatories, which are questions that go out to somebody and they have to answer under oath, or requests for production of documents, or taking depositions. If you actually want to get somebody in and take their deposition and have them make statements on the record, that's where you're going to do it, in a circuit court lawsuit. I've had people come in and say, you know, I'm owed $40,000 by this particular client. Should I sue them? Or they've made the decision that they want to sue. They say, where should I sue? I say, well, jurisdictionally, you would have to go to the circuit court. But you want to wait 18 months, or, well, I'm not trying to talk you out of not getting exactly what you're owed. We can get this case in front of a judge in 6 weeks if you're willing to file it at 30. Essentially, take that $10,000 as a haircut. And again, I'm not trying to give away people's money. It's a matter of what you're willing to, how long you're willing to wait, and how quickly you want to move. It might be on the next slide, but one of the other things you need to be aware of is you can have, there are circumstances where you can have the case moved from district to circuit court. Somebody sues me for $25,000, and for whatever reason I think I want a jury. I'm entitled to it. I can demand it. By making the jury demand, the case has to be moved over to the circuit court. I don't know whether I should be proud of this or not, but I sometimes use that strategically, where part of my defense is just to spend the other guy to death and say, you thought you were going to get in front of a judge in 6 weeks. I'm making my jury demand. You're in it for 2 years now, pal, and I'm going to start deposing your witnesses and all the rest. You ready for that? And then they'll say, well, maybe we won't take, maybe we won't demand the whole 25. Maybe we talk settling. So, another thing to be aware of is in circuit court, there are certain types of remedies beyond money that are only available in circuit court. If you're looking for a declaratory judgment, you don't necessarily want money, or money is secondary. What you really want is the judge to adjudicate that the situation is A and B, when the other guy says it's X, Y, Z. For a declaratory judgment, the judge saying this is, by court order, the state of affairs, you want that in circuit court. Circuit court's the only place they can do that. That's essentially that type of thing, or what we refer to as an equity order, enjoining someone from doing something. You don't want money from them. You want them to stop walking up and down in front of your business with a sign saying, this guy is a cheater. The only court that can order a person to do something or not do something would be the circuit court. I am admitted in Delaware, and we actually have in Delaware an entirely separate court called the Court of Chancery that cannot grant you money judgments. They can only give those declaratory type judgments. A lot of the corporate governance issues out of the 80s with leveraged takeovers and those types of things were brought by shareholders, and none of them, they had billions of dollars at stake, but none of them was asking for any money. They were asking for the court to order that the board of the company make a particular decision to sell the company, or that the CEO do one thing over another. In Maryland, that's only done in the circuit court. Small claims, 5,000 or less, I'm certainly not going to call the district court any, kangaroo court or anything like that, but the rules are relaxed. I was in district court this morning down in Charles County. The judges in district court want to get to the heart of the matter, find out, get to brass tacks, find out who did what and who owes what to whom. If you are unhappy with your district court outcome, my guy today, in my case, we had sued for $15,000. The other guy countersued. The judge ordered for my opponent for $8,000. The conversation I had with my client on the way to the courthouse was, one of the rights you have is an appeal. Now, to district court, you can do it two ways. You can do an appeal on the record, which is sort of what maybe most lay people think of as appeals, saying to the judge in the circuit court, something in the district court below was wrong. Some evidence came in that shouldn't have, or some evidence shouldn't have come in that did. You can take that appeal, we call it on the record, up to the circuit court and say, Judge, tell us legally whether this went right or went wrong. One of the nice things when you want to take an appeal from a district court decision is that you can also appeal de novo. What that means is you get a brand new trial. It's not saying, Judge, there was legal error below. It's saying, I simply don't like the decision. I want to try it again in the circuit court. Well, that becomes a very, very detailed conversation about whether it's reasonable to do it and whether it's cost effective to do it. I don't mind telling you that the conversation I had with my guy today was, if you want to take an appeal de novo to the circuit court, you are going to spend at least as much, if not more, than the judgment that was just entered against you to retry it. And we're now opening the door for our opponent to bring in 3 more expert witnesses if he wants to. We can bring in more expert witnesses. You're putting a stick of dynamite in that thing, and you better be prepared for it. So, but it is a nice option. If you simply, you don't have to point out legal error. If you simply don't like the decision that you got, try it again.
Do you have a time frame that you have to file?
We will get to that. Yep.
Oh, okay.
Thinking ahead.
Typically in district court, you want you can have an officer or an owner, but in a small claims action, you do have to have an attorney there for you. You'll often see credit card companies will have local representatives who are not attorneys in district court, just reading down case after case after case for small claims that have been filed. This is to address your question. Waiting periods after that judgment comes in, and this is, let's all say you all are in possession of a judgment, you're chomping at the bit to turn it into money. You got to wait 10 days to begin with, because that court order actually isn't good law. It's not a full adjudication until 10 days after it's entered. There is then, for most purposes, a 30-day period for filing appeals. You get the judgment. There's been no motion for a new trial. There's been no appeal taken by the guy who owes you money. Now it's time to turn it into money, turn that judgment into money. How do you go about doing that? Well, we use what we call discovery methods. And just like during the case itself, when you send interrogatories out saying, where were you at this time, or what did you contract to do or not do, and they have to answer under oath, we send interrogatories out to the guy who owes us money and says, where do you bank? Where are your depository accounts, your checking account, your savings account, any certificates of deposit? How much are the tires on your truck worth? When did you buy them and how long ago was that? How many miles are on your fleet vehicles? I mean, it starts to get a little grubby and a little nasty, but this is what collecting money is about. They have to return those interrogatories to you, again, under oath, telling you where they bank. If they don't do that, you file a motion to compel, and these are all sort of a show cause order. It gets dragged into court. Why didn't you answer the questions? But hopefully, and this is another one, you can ask the court to order him to show up, be put under oath, and be asked those questions in person. We call it an asset deposition, or an oral exam. Find out what assets are out there. Let's say you make the decision that you don't want to send out these interrogatories, or you don't want to get the guy in there and actually answer questions, you can send out subpoenas, which have the force of a court order to banks to see, does he have any accounts there. You can also do a garnishment, and I have done this where I didn't know specifically where my guy banked. I say my guy was a company, where they maintain their corporate accounts. So I filed requests for writ of garnishment for non-wage assets against basically every bank in the town where the company is located. That's filed with the court, and when the court orders it, they will then issue out that order to the bank. And my hope is that these guys go to buy lunch for the staff on Friday, and the account's frozen, because my garnishment has gotten them, because they owe me that money. Frankly, they owe my client that money. Request for writ of execution. I don't know why the Godfather is there, but he... now I remember. Garnishing wages. So you have... We've talked a little bit about liens and when you could use them to foreclose, when you could use them simply as leverage. We've talked about writs of garnishment for bank accounts. They take a little bit of time, but they're not particularly complex. You also have sort of the ultimate nasty business, and that's a writ to garnish wages from someone. Let's see, writ, bank account, personal property, real estate. Let's talk about personal property. You're essentially going to file a request for a writ that the court is going to issue an order to the sheriff to levy personal property. Go out there and tag the pickup truck and say, this is going to be sold at auction to pay off your debt. They're a little more involved. But garnishing wages, you're going to get a little bit at a time, and very often I am in the position where I've got a client who has a judgment against somebody, and I say, do you want to collect $40 every 2 weeks for time immemorial, or do you want to take $2,500 in ready cash that this debtor is waving under our nose? And everybody thinks garnishing wages is, not to say they think it's fun, but they think they're really turning the screw on the guy. Maybe you are, but you are going to get a drip, drip, drip of money that is not going to be very efficient for you from a business point of view. So you can do it, and it really does make life painful on the garnishee, your judgment debtor, but it's a tough way to get paid what you are owed. Judgment's valid for 12 years. You're going to do it for additional 12 years. As you get paid, you're going to net out what you got paid, and once it's satisfied, you file a satisfaction of judgment. If you forget to do it, and that judgment stays on the record, and part of the reason you want to do it is because somebody doesn't want a judgment still recorded against them that has been paid off, that they've paid off. If you, as the lawyer or the person going after the money, you get paid in full and you forget to do the satisfaction of judgment, the guy who owed you the money can have his lawyer do it and then bill you for the fee, and you're obligated to pay it. There we go. All right, I am going to turn the next section of the presentation over to Josh Wellborn. Josh and I work hand in hand doing bankruptcy cases, again, on behalf of debtors, as well as on behalf of creditors. You all probably most interested, sort of given the tone of the presentation, in what happens as a creditor. What do you do? What precautions do you have to take? Are there any red flags out there? And there certainly are. So that's where Josh is going to begin, and the Section 362 automatic stay is the ugliest part of the code for a creditor trying to collect money against somebody who files bankruptcy. So I'll let Josh take it away.
How's everybody doing? And just like Paul, if you have any questions, feel free to interrupt me. And Paul, if I say anything that's not true, interrupt me too. Okay. I think these next two slides are really about protecting yourself as a creditor from liability as you go about trying to collect on a debt. And one of the things, what happens when a debtor, somebody who owes you money, files for bankruptcy. One of the most important things in terms of being a creditor is that this 362 automatic stay triggers and goes into effect. And basically what it means is that all collection activities against the debtor have to cease. It's almost like a court order ordering you to stop collection activities. And it doesn't matter what you're doing, sending letters, phone calls, you're about to go to the court the next day, or you're trying to collect on a judgment. All of that has to stop.
An invoice, a ordinary course randomly, not randomly, an ordinary course generated invoice, automatically generated invoice sent to a customer who has filed bankruptcy is a violation of the automatic stay. You don't even have to make the decision to do it. If it goes out, it's a violation.
Exactly. And there's penalties for violating the automatic stay. Federal law actually gives the debtor a cause of action against you as the creditor. They can sue you for damages and you can get their attorney's fees. So it's very important to watch that. So if you have a debtor who's telling you that they're about to file for bankruptcy, you might want to hold back. You can check the bankruptcy docket to see if it's actually been filed.
If somebody gives you, and I don't mean to interrupt too
No,
much, Josh, but we really are a team and do a lot of these things together. If somebody tells you, I'm going to file bankruptcy, my general position is you and everybody else, until you have a case number, I don't care. But I'm then on notice that this guy is telling me he might do it. If he tells you, I have filed bankruptcy, that is very serious. Whether he's being truthful or not, we don't know. By all means, if somebody tells you they're going to, or somebody tells you they have, call us. There's no charge for it. We're happy to do it. Josh and I are both admitted to the federal bankruptcy bar. We have access to every bankruptcy docket in America. We log on and for free check and see whether that person actually has filed or not. Take 5 minutes. We don't mind at all. Call us. We'll tell you whether they filed or not. Because if they have, you then really have handcuffs on it that Josh is going to talk about a little bit, or has talked about already actually. And you'll need to take some special steps to try and collect that debt. And you've already sort of alluded to how complex they can be. But yeah, if you have reason to believe that somebody has filed or is about to file, call us. We're happy to check and tell you. Better to know than not know.
And next I'll just go over a couple of the more common bankruptcy chapters. It's chapter 7, 11, and 13. And it's important to understand them because really your chances of recovering anything from the bankruptcy really depend in a lot of ways on what chapter they're filing. Chapter 7 is a liquidation. And what happens is a bankruptcy trustee collects all and gathers all the debtor's assets, non-exempt assets, and sells them. Any money they get from the sale of those assets and go to satisfy creditors. A lot of times, all the debtor's assets are exempt. Maryland statutes provide a number of exemptions. And most times those exemptions are enough to cover all the debtor's assets, so there's nothing for the trustee to sell. There's no money coming out. It's known as a no asset, Chapter 7, and the creditors collect nothing. Chapter 13 and Chapter 11 are different. They are not liquidations, they are reorganizations. Chapter 11 is for corporations, Chapter 13 is for individuals. And also point out that a corporation can also file a Chapter 7. And what happens in these chapters is that the debtor restructures and reorganizes his debt, and over the course of 3 to 5 years, pays through a plan and pays off some of that debt. Generally, though, for unsecured debtors, they only receive pennies on the dollar. So it's not, most of the time, you're not going to be made whole, but at least you get something back.
That's one of the ways to think about it is if you are secured, and again, because we've talked about this in terms of your example, if you're secured, you're going to have to be made whole through the case. You have to be repaid, like in a mortgage arrearage. Okay, if somebody files a Chapter 13 because they're 6 months behind and they want to stop foreclosure. The bank has to be repaid its arrearage through the plan with interest by the end of the plan, by the end of the 5 years if it's a 5-year case. You're going to keep making the regular mortgage payment. The bottom line is that secured creditor cannot lose position because of the bankruptcy. Unsecureds, on the other hand, they get whatever, once all the assets are, if there are any, are sold, or the debtor comes in and says, here's what our budget allows us to repay our creditors, you're going to get that, and if you're unsecured, that's all you're going to get, and the remainder is discharged as forgiven.
Yeah,
One thing that was up on there, Josh, I
Yeah.
want to say was, in both the 7 and the 13 and the 11, keep in mind, 7 can be a liquidation for either an individual or a corporation. If an individual wants to reorganize his debt, repay some of it and reorganize it, that's a 13. If a company is reorganizing its debt and repaying some of it, that's a Chapter 11. As potential creditors, the most important piece of paper you're going to receive is called a proof of claim. And some of you may know about that already. If you receive a proof of claim, it's going to give you instructions about how to assert the claim that you owe, how to assert the amount that you say you're owed from this debtor. In most cases, you are going to file it with the court. You can do that through us, you can do it yourself. In some big Chapter 11 cases, there'll actually be a claims agent appointed. For some reason, they're usually in California. And what you're filing is the form that says, here's what I'm owed. It's based on contract or some other reason. Here's what I was owed as of the date the case was filed. That's the most you can ask for. Even if it may be accruing on your books after that case filing date, that's not going to be part of your claim. It's only the date, snapshot of the date, the debt that was owed you the day the case was filed. You're going to lay that out. And then it's going to say, what's this based upon? You're going to say, see attached. And we attach a typewritten narrative explaining how this debt arose, a copy of any contract, whether it's a lease or a sales contract, who knows what it might be, promissory note. And then usually we give a spreadsheet of how the debt accrued, any interest that kicked in, and any fees and all the rest. File that by the date that's given. If the FedEx plane crashes on its way to California and it doesn't get filed on time, you're out of luck. That date is the hardest deadline I know in the law. There's no arguing that the plane crashed. There's no arguing that the dog ate it. The thing has to be filed, and if you don't file it, you are out of the money. That money is gone. Are you freaked out enough if you get proof of claim in the mail you call it?
Okay, the Fair Debt Collection Practices Act and the Maryland Consumer Debt Collections Act. These are two consumer protection statutes that really protect debtors from abusive collection practices. The first one is a federal statute, and the second one is actually, obviously a Maryland statute. The first one, the FDCPA, only applies to people who regularly collect debt. It doesn't apply to the original lender. So if you loan somebody money and you're calling them to collect that money, the FDCPA would not apply to you. Okay, it usually applies to collection agencies. Somebody buys the debt from you and then they go to collect. It also doesn't apply to debts incurred during the course of business. It only applies to consumer debts, not business debts. So it's pretty limited. And it prevents things from harassing phone calls, false statements, and unfair collection practices. You couldn't call somebody up and say, if you don't pay me by tomorrow, I'm going to send the police out and they're going to throw you in jail. Or pretend you're working for the government and say, if you don't pay, we're going to hold your taxes. Really extreme practices, which I don't think are too common anymore, but I think they were. If a collection agency violates this act, they can be sued by the debtor. They can be sued for their actual damages, but a lot of times there's no actual damages, it's just harassing. In that case, the statute allows for a recovery of $1,000. So this statute really doesn't have a lot of teeth, at least when it comes to protecting consumers, but it's out there.
My recollection is there's some strategic things in it. If we're representing somebody who has begun to get these demands, and they'll always say this is a demand from a debt collector, one of the provisions, as I recall, and Josh knows more about these statutes than I do, they have to put in there that you are entitled to demand proof of the debt or the substantiation of the debt within 30 days. And sometimes we will do that as a strategic issue. We may know what the amount is and how it came to be, but we may want the collecting party, we want to sort of cross-reference our records against theirs, and they do have to show that to you. And it also buys you some time while you may demand it, and then we often end up calling and saying, look, what you guys really going for here? Can we get terms on it? That kind of thing.
That's correct, yeah. The Maryland statute, it has more teeth. One is broader. It applies to anyone who's trying to collect a debt. So it would apply to the original lender, would apply to them. But again, it's only for consumer debts, it's not for business debts. Another thing about the Maryland statute is that the damages, the debtor can, if he's successful, can receive a greater. They can receive damages for their emotional distress, even if there's no, you know, they don't have to go to a doctor to see it, for their emotional distress, you know, mental injury, you know, with or without accompanying injury. So it has more teeth. I think that's all I have, really. Do you have anything to say about that?
I don't. Again, this is not really my area. Josh knows it better than I do. But is that the end of the slides also?
I think there's one something to that.
Okay.
Just answer the questions.
Yeah. Always like to open up the floor for general or specific questions.
I can't really, so excuse me if you covered this, but is the general rule, debtors will often try to retitle something to avoid it being secured in bankruptcy. What's generally the time limits on that? I didn't phrase that very well.
No, but what we're talking about is what we call, what the bankruptcy code and other codes call a fraudulent conveyance. Essentially, you are moving assets around to keep them out of the grasp of your creditor. You retitle a fleet of vehicles in another corporate name, or you retitle a depository account in another entity name, or you sell your Ferrari to your nephew for $1. And this is to keep things. And those transactions can be unwound by a bankruptcy trustee. Typically, what the trustees are they're looking at a window back about 6 months, and what they're saying is not only did you sell anything, and if you say yes, they're going to say for how much. They're also going to say, did you encumber any of your assets with liens? Because now you've put somebody else in a higher position. If you've got something that's worth $50,000, piece of property, you lien it up the night before you file for bankruptcy. Now that secured creditor is going to be in a priority position to bankruptcy, as opposed to that asset being available for liquidation to pay out the debtor company's creditors. So avoid it, and people say, well, I do have assets I want to get rid of. The company has assets we want to get rid of. When should we do that? And I say, after warning them, I basically say, if you're going to do it now as far out from the case being filed as possible, because there are sort of reasonable business decisions to be made to liquidate assets. You can't do it in a way that's going to prejudice your creditors as a whole.
But as a general rule, you can give your Ferrari to your nephew 6 months before and get away with that?
Depends on your answer to the trustee's question, and what's in your schedule. But generally speaking, 6 months is the line. If you are an insider in a company that files bankruptcy, they're going to look at transactions by insiders that go back a year. That's a different line, but that's sort of where the trustee has, it's actually the United States trustee working with Congress to draft the code has said, what's reasonable for us to look back?
My nephew will be glad to hear that.
To get your Ferrari for $1? See me after the
I'll give you $2.
Hey, I'll give you 3.
It's a question. I'm a real estate agent, and so now my question is, foreclosure, still saying, I want to know, if you foreclose on a residential property versus being foreclosed on a commercial property, do the same rules apply?
No. Commercial is much simpler. You are held by most jurisdictions in the commercial context to be more sophisticated.
So they don't have as much time?
No. A residential foreclosure, as you probably know, I mean, can you get a residential foreclosure done in under a year in Maryland anymore?
No. Over commercial you can.
There are a number of extra steps and protections for residential, especially owner-occupied property, within the past year or two that have gone into effect, given all the nasty practices that were going on with mortgage lending. So right now it is, Amber and I both worked over in the circuit court for Judge Krieger and Judge Claggett.
This is Dave Weigel and Amber Rife. They are new attorneys here at the firm. They clerk for our 2 circuit court judges, which we consider a nice feather in our cap. But part of what they saw, and it's really been the last 3 years or so, where the consumer protection provisions on residential foreclosures have become, I don't call it onerous, because I'm not in a position to say that. They just are what they are. They are a lot now.
Yeah.
But Dave and Amber have seen these cases work their way through the circuit court, in some cases, grind to a complete halt.
There was, we both, excuse me, we both started in August of September 2010. Within a month or two, there was a statewide, they call it foreclosure summit, to discuss all these things that were going on. The legislature had just passed, I think effective July 1 or July 31st, 2010, a new set of requirements, including this foreclosure mediation. The foreclosures now in the residential area have sort of ground to a halt, whether it's the banks negotiating with all the attorneys general, or they're just trying to figure out how to negotiate these new steps. But to get back to the original point, the residential foreclosure process is much more, I don't know if tedious is the right word or onerous is the right word, but compared to a commercial practice, a commercial foreclosure is probably, what, 2 or 3 times?
Easily.
And now you're seeing more and more borrowers who have clearly been listening to the news, filing things, saying, oh, hey, Bank of America, you did X, that applies to me. So lenders are getting more savvy about the issues to raise, too, is another thing you have to watch out for. You really need to make sure your attorney is doing it correctly, because courts are really cracking down on that.
Okay, I'm an REO agent, and I know it was taking between 6 and 7 months. So now my question is, how long does it take for a commercial building?
Commercial can be done almost in, 45, 60 days, or something like that.
That sounds about right.
Wow.
And actually, Dave, if you don't mind, because you did sound like, maybe, for those of you who don't know, you would introduce yourself, just to, we made everybody else do it.
Dave Fagan, I own the Prince Frederick Shopping Center.
Okay.
And
And
if they,
Apologize for being late.
just wanted everybody to know, didn't mean to call you out, didn't know who you were.
oh, I was just gonna say, and doesn't bankrupt, if the people owning the house declare bankruptcy, doesn't that push out even more?
Sure.
Because it stops everything.
Yeah.
And they've alluded to this new mediation, you have to be offered mediation as part of a residential foreclosure,
If it's in our
right?
If
And that's
it's
just,
unauthorized?
owner occupied.
yeah, I represented banks where we did foreclosures, and the husband, we got to the steps of, this is when I was first starting out, and we get to the steps of the house to do the foreclosure sale, at 7 o'clock in the morning, and I'm there, I was the lowly associate, I was up in Baltimore, and I'm on the phone calling the clerk to see that morning, well, this was before smartphones, to see, I don't know how long ago, to see whether a petition had been filed. Petition was filed by the husband. It was jointly owned. Petition was filed by the husband. That stops the bankruptcy. We did a consent order whereby they're going to, and we had to shut down the sale and everything else. File a consent order that says the arrears are going to be paid this way, everything else. Never made one payment against the consent order. Bankruptcy gets dismissed. We have to re-tee up the foreclosure.
And then the
Same
wife.
house, same morning, wife filed.
Wow.
So they've now stretched that out, in that case,
They know how to
about
play the
25
game.
months worth of work.
Yep.
I'm not sure we ever got the house.
I can tell you, at least down here, what we had started to do towards the end, because we saw this, the bankruptcy, them sort of running to the courthouse to turn in the bankruptcy petition or the notice of filing of bankruptcy is, we had generally just sort of stayed the proceedings. We told the parties, you can file whatever you want with the circuit court. We're going to take no action while the bankruptcy stays in place. But notify us as soon as the bankruptcy stay has been lifted. And we actually were going to start setting a tickle in the system where 60 days after getting the notice of bankruptcy, we were going to call the foreclosing attorneys and say, hey, what's going on? We need to clear our dockets out. So I think courts on the state level, at least in Coward County, are cognizant of the fact that those bankruptcy practices are going on and are sensitive to that.
Is bankruptcy more difficult now to file? Or is it?
It has, since the Bankruptcy Reform Act in 2006, it changed drastically on the personal side. But that's now 5 years old, so it became tougher, in particular to file a Chapter 7 case. There was a means test put into place, but they're not talking about instituting entitlement programs. This means test compared the debtor's income with the median for the state where they live. That was an initial hurdle to get into. So as of '06, they became more difficult, but those things now have they haven't gone away, but they've been incorporated into the practice. So cases that are getting filed now are, I like to think, less abusive than they used to be.
Speaking to that, if a person files bankruptcy to delay a foreclosure, can the judge deny the bankruptcy filing? I mean, because they meet the median whatever?
No, the way it happens is you file a petition that's done electronically, and it's actually called an order for relief. When the case is, the reason you file a bankruptcy petition, print out the confirmation and walk over the courthouse steps and hand it to the auctioneer the morning of and stop the case. Because that order for relief is, and it means relief from pursuit by your creditors, is entered without any judicial intervention. It's entered as a matter of right. You get it in a fairly short window, 60 days, 90 days. It will be actually shorter than that in some cases. You'll know whether the debtor filed this thing in good faith or did it just to stop
everything.
Right. And if there is no good faith in it, it'll either die on its own because the right schedules and records weren't provided, or the creditor can file a motion to lift the automatic stay and say, Judge, we're not being proposed by this debtor to be treated properly. Let us out from under that 362 automatic stay and let us proceed with our natural state court rights.
So it's only a temporary stop then, if they are actually...
If they're actually doing what they need to do, the debtor does what they need to do per the code requirements, and it becomes a valid bankruptcy case, the automatic stay stays in place for the entire case. And bankruptcy is about money and arithmetic, but it's as much about control as anything else. And what I mean by that is, if you have a repayment bankruptcy, a corporate Chapter 11, or an individual Chapter 13, you can propose to repay your creditors certain percentage levels and treat secured debt as sort of a private bankruptcy case outside the law. But that's negotiation. By filing a bankruptcy, you are, even if it was under the same terms, you are telling your creditors, because we're now in bankruptcy, here's what you're going to take, here's the percentage you're going to take, and that's what you're going to get. You are really driving the bus in a bankruptcy case. It's as much about control as it is about math.
So you can control what the bank is going to get in return then?
Yeah, as long as you stay within the provisions that the code requires. Again, secureds have to be made whole throughout the life of the case, and you can't transfer assets in an inappropriate way, and a million other rules. As long as you do that, you're telling the creditor what they're going to get, and they have to take it.
Wow.
Well, it takes you longer to file for a lift stay and get it than it would to a Chapter 7 go all the way through to discharge.
Often, yeah. A 7, if done right, is done in 4 months.
Right.
Well, an individual 7.
Paul, if you have a borrower who is really abusing the system, just filing time and time again, what is you as the creditor's attorney, what's the quickest you can get relief from the stay? I filed for the 4th time. My house is about to be foreclosed. For the 4th time I filed, where my wife has filed bankruptcy. If you go to the bankruptcy judge and say, Judge, this guy's, you've seen this guy, you know him. What is the turnaround?
Well, I'll ask Josh to jump in if he disagrees with me, but generally you're not going to see that kind of filer because there is, again, in '06, they put these provisions in. You can't have a discharge. The discharge is the debt forgiveness. You can't have discharges within 8 years of one another on an individual Chapter 7. And for a 13 following a 7, I think it's 4 years. If the person, those prohibitions against refiling come into play if the person voluntarily discharges voluntarily dismisses the case or dismisses their own case in response to a motion to lift the automatic stay.
Right.
They're going to be prevented from refiling. So the serial filer is sort of dying out.
But I guess and Amber and I saw it in the circuit court, and I think probably
Yeah.
for real estate agents, I think what they're sort of hinting at is people do serial file, and I can tell you from